Welcome back, Nuggets. This mother clucker's got some thoughts. Let's ruffle some feathers and get into the video. And if you'd like to support my baby chick of a channel, don't forget to like, subscribe, and hype this video, and go check out my other videos while you're here. Okay, my nuggets. So this is a kind of sort of update to the lawsuit involving Eugenia. Now, this is my third video on this topic, and if you haven't watched my other two videos, I really encourage you to stop this one now, go back and watch those first, and then come back and watch this one. I won't be going into depth in the actual case itself because I've already covered that, and especially if you've watched other people's but not necessarily mine, I do encourage you to go watch them because already I'm getting people commenting on my videos telling me false information about this lawsuit as though I wasn't the one that brought it in the first place. And I'm guessing that there's a lot of misinformation going on out there. So in my videos, it's all verified because it's all directly from the lawsuit itself. And I'm really clear if I am speculating on something. So definitely go check them out if you haven't already. But if you have, let's get into this sort of update, and I will explain what I mean by sort of, but just a little bit of interesting stuff that popped up before we get into it. So in my last video, if you remember, I was really concerned about the fact that the legal documents themselves had the incorrect date of the Mother's Day incident. They are citing the 23rd of May, which is actually when a whole bunch of news articles went out about it, not when the Mother's Day event happened itself. And I wondered if the documents was telling the social media companies to say, look for more discovery information on or around the 23rd, would they completely miss the actual Mother's Day incident itself and therefore kind of find a little loophole being ignorant in a sense? And I was worried about that. Would the judge himself know to actually go look earlier because there's quite a date discrepancy between those two events? And I asked any law nuggets to pop up in the chat and tell me what you thought, and one did. Now, I have blurred the name, but if you're here listening and you want to make yourself known, go ahead and say hello. I'm just blurring names as it's just a process moving forward now, to just in case. You never know. They said, American lawyer here, the words on or about date is doing the heavy lifting in this discovery motion. Plaintiffs are asking for discovery or facts. The goal of pretrial discovery is to gain more accurate facts regarding the legal issues being argued. As such, plaintiff being off by a day or two in their pursuit of discovery documents, the court isn't going to necessarily see this as a terminal error or a problem. After all, the entire point of the plaintiff's exercise of discovery is to discover the most accurate facts. Sometimes, and in brackets often, discovery will correct the facts as the parties may know them at the start of the case. So at pretrial, not the biggest deal for a non-party, not the target of the lawsuit. I was so grateful, and thank you so much for responding to this because it is something that I was concerned about. But what I raised is that it wasn't actually just a couple of days off. It was actually nearly a couple of weeks off. And I was questioning, would the judge even know to be looking for issues around May the 11th, in the first place? Because if even the plaintiffs themselves didn't know that date, then does everybody else know to look at that date? And they gave a wonderful explanation. So they said, this case is in a phase called pre-trial discovery. Even if the plaintiff's original request of records is off by 2 weeks, in this phase of proceedings, it isn't a problem. The incident or occurrence must be reasonably described such that the other party being asked to deliver information about it can find it, which this was a really significant event on Eugenia's channel, so that makes sense. They're looking for the event, not the date. After all, this is the quote-unquote fact-finding phase. The reason you ask for more facts is to make sure that when the actual trial takes place, the plaintiff can reference the discovery materials they received and make correct assertions of time and dates. Think of it like this. You noticed your pink sweater is missing on the 8th. So you ask someone who came to your house around that time, hey, did you see my pink sweater last week? Around the 8th. This is discovery. let's say Abby, the friend, responds and says, yeah, I saw your pink sweater. Here's a picture of Jenny, the thief, wearing it on the 4th. Are you wrong for thinking it was stolen on the 8th? No, maybe a newspaper prints that Vera's sweater was stolen on the 19th, weeks later. When Jenny the thief finally goes to trial for stealing, you can then present the picture you've received during discovery from Abby the friend, reflecting a more accurate date of when the theft occurred. With this new information, you can tell the court during trial Jenny the thief was pictured in the stolen sweater on the 4th. At trial is when facts need to be as correct as possible. So thank you so much for clearing that up, because I was really concerned that, oh, these social media companies are just going to use this as a complete loophole and nothing will come of it. So I love this explanation. It's so clear and yeah, perfect. Okay, so where we left off in the last video was that the judge had ruled that TikTok was to supply additional discovery documents from Eugenia's Mother's Day incident and to deliver them no later than the 10th of November. Now, all of my law nuggets are going to laugh at me here because I was naive and I thought what that meant was they would file all of the discovery, they'd be put up on the websites that I'm looking at, all the legal documents, and we would have all of this information about Eugenia and see what TikTok actually knew and what they were doing, and it would be very interesting. That's not what happened, my nuggets. So I've actually, you know that I'm pretty new to dealing with the legal side of things and delving into legal documents. And it's all been incredibly interesting. And I'm developing this whole new skill set around being able to find them and interpret them and know what can be skipped and what's important. And it's become this really fascinating puzzle for me that now I'm deep into at this point. So I have notifications set up for this case, and there, as you know, this is a massive case. Now, on the 7th of November, 1,184 exhibits went up in relation to this case. So this is pretty much the plaintiff's discovery all going up. And I wasn't sure at this point whether or not Eugenia's would have been mixed in with these, because most of them, and when I say most, I mean all but a handful, were put up with requests to seal. And what that essentially means is they're not accessible to the public, or they come up with, like we saw in the previous documentation, big black redacted bars all over them. So either completely sealed in its entirety or bits and pieces of it, and most of them seem to be in this state. And when they are redacted or sealed like that, you can't actually just search for the text in them, so it gets really complicated. So I'm thinking, did the Eugenia stuff go up in this lot, or is it yet to come? And I'll get into that a little bit later. But what I did find, what I was able to find was, do you remember that there was a deposition with a TikTok employee who apparently spoke quite in depth about their knowledge circling around Eugenia? And this is the same employee that called her a barn burner, which, thank you everyone for explaining what barn burner meant. And that is so inappropriate. I cannot, for an employee to reference Eugenia as a barn burner in a deposition is just all kinds of gross, really. But her deposition did come up in the exhibit list. There are two references that come up in the sealed document list to this particular deposition, and you can see it here, exhibit number 492. But if you look just below it, there are only two there that are available to the public. That's exhibit 466 and 467. They're the ones that are public. All of the others that you can see in this entry are sealed, and I'm going to explain what this means very shortly. The second one is also sealed, as you can see, and there are a few more in this particular release that are available to the public, but none of them pertain to Eugenia. But another document came with this absolute inundation of exhibits, and that is the plaintiff's corrected omnibus opposition to defendants' motions for summary judgment. Now, this is a very, very interesting document. So what is an omnibus brief? For my non-legal nuggets, I just found this interesting, so I thought you might too. Omnibus is Latin meaning for all or containing many. So in this case, in legal terms, we're talking about a single document that addresses multiple related issues or parties at once, rather than filing separate documents for each. So essentially, in this case, of course it can be used for many things, but in this case, the four defendants, Meta, TikTok, Snap, and YouTube, all filed their own separate motions, basically saying, we should win this without a trial. No need for a trial. Let's just, get it over with. And the plaintiffs, this is all the schools and the government and the parents, they're all saying, no, no, we need a trial. And that's what this document is addressing. So rather than providing a different response to each company, it's all in one document that addresses all of the arguments, all of the evidence, just basically one massive collation to save time. And that way the judge is reading one document versus many. But I think what is most interesting in this document, it is a 235-page document, and 171 consecutive pages are completely redacted. And when I say completely, I don't just mean like we've seen in the other documents where there's a black bar over a name or here or there. I mean everything except the headings is blacked out, and that is just absolutely insane to me. This is all surrounding, I'll put up the menu items on the screen so you can see them, but it's basically surrounding their business models, what they knew, targeting school-age children, what they knew about the harm, misrepresentation and manipulation, and interestingly, specifically about TikTok, because that's what we're talking about mostly, TikTok's failure to exercise reasonable care, TikTok's targeting of schools, their knowledge of harm, TikTok's addiction problem was known, acknowledged, and profitable. TikTok's executives and employees struggled with addiction, and its co-defendants knew how addictive TikTok was. TikTok intentionally engineered addiction. TikTok knew its platform was harming users' mental health, sleep, and schools, but chose profit over prevention and failed to exercise reasonable care. It even goes into things like the beauty filters and the ugly side of beauty filters within this document. And TikTok's failure to warn parents, educators, and schools about known mental health risks on top of everything else. And one extra paragraph that really stood out to me that is quite heavily redacted. This is before all of the giant amounts of pages that are redacted. And I quote, "Internally, Meta researchers minced no words. Redacted. Meanwhile, TikTok researched. Redacted. Snap acknowledged that. Redacted. YouTube, despite knowing, redacted." So basically what this is telling us is that all of these companies said, we do not want this information out to the public. And I'm going to leave the scrolling of pages on the screen as we go through while I talk about why these are being sealed, what might happen in the future, and basically what's going on. When these documents are submitted, the lawyers representing, so the defense lawyers that are representing the social media companies, can basically say to the judge, we don't want these out to the public. And legitimate reasons, and please, my law nuggets, if I'm missing anything, this is just from my research, so jump in if I've missed anything here. But legitimate reasons that courts might approve something like this is trade secrets. So essentially these companies saying this is how our algorithm actually works, and that would give our competitors an advantage if it got out there, so we can't have this information getting out there. It can be privacy protections, so like names of minors, medical information, personal data. That I get, that makes a lot of sense. Proprietary business information, so internal research, financial data, strategic plans, things like that. And I think probably what a lot of them are arguing is ongoing investigations. So not wanting to tip off other potential defendants. And why I think this is a really important one, because if you remember, this is not a class action lawsuit. This is a MDL. So, a class action lawsuit is where you might have a lot of people who have been affected by social media, for example, but it comes down to one plaintiff, one person representing many, compared to the MDL, the multi district litigation, is basically a group of people, all with their own representation, moving in as a group of affected people. So there's a lot of lawyers involved and a lot of plaintiffs involved, and it's kind of everybody acting independently but all coming together in the document section, if that makes sense. So why that's different is because a class action lawsuit will have a cutoff for people to enter into the class action, and once that date has passed, then you can't get any more people, right? So then it doesn't matter if new information comes out or anything like that. But in this case, for example, YouTube puts out some discovery that makes somebody else go, oh wait, that happened to me on TikTok. Then you've got this new person potentially getting into the mix, or existing people expanding upon their issues, and these companies don't want that. I think, I am speculating, but I think that's what's going on here. I also think it would be very easy for these companies to claim algorithm privacy, because I think, when we're getting into the workings and what they store and all of this sort of thing, I don't know. I think it's very easy for these companies to say and prove to the judge that things need to be sealed for our safety, right? From what I've researched, it seems like entering in paperwork requesting to be sealed is pretty normal. And at that point, the judge will either approve or not approve the confidential framework. And oftentimes, what will happen if they do want to submit something as confidential, there will be a sealed version, which the public can't see, just the judge and parties will see. And then there's a public version, which is what we're seeing with all of the black bars across everything. Then there's a motion to seal. The party, in this case, the social media lawyers, file an administrative motion to file under seal. And in that, it explains why the sealing is necessary. And this can be a temporary seal while it's pending the decision, or permanent. And that's why in that first document I found, it had a lot more redactions in it, and then I found an unredacted version. So the judge, in between those two releases, the judge had gone, this is fine to stay redacted, but this isn't okay to stay redacted. And that's why we were able to see some extra things. So it really does come down to the judge's ruling. That doesn't necessarily mean that it will be sealed forever. There can actually be motions to seal from media organizations or public interest groups, or basically arguments saying the public has a right to see this, or the information is newsworthy and already partially public, which might be why we do see unredacted things around Eugenia, because she is a public figure and we can already prove this, right? We've already seen it. We know what's going on. More reasons that things might get unsealed after trial. There's, less reason to keep things secret. Sometimes a settlement requires disclosure. Sometimes appeals courts may actually require more transparency as well. Or sometimes just as simple as a person was a minor and so therefore being protected, and now is an adult and there's no need to have that kind of protection on them anymore. But you'll have to tell me as well, my lawyer nuggets out there, this seems like excessive sealing, like 171 consecutive pages of nothing but black bars. And here's what I think is going on, why we're seeing this level. Because 4 major social media companies who are the defendants all want protection. They don't want any of this getting out there, right? The public are their consumers, and that's how they're making money. I would hazard a guess that this document contains internal research showing exactly what these companies knew about and how they knew that they were harming minors. I think it contains internal communications about platform design choices, because I've said it once, I'll say it again. TikTok has mastered gamification and intense and compulsive interest towards their platform. But ultimately, and I think probably the biggest thing, these companies probably have the best lawyers arguing for maximum ceiling. Like, I can only imagine the caliber of lawyer that these companies have access to. I think what we can take away from this safely, because bear in mind, it is the companies themselves who are asking for this ceiling. I think it's safe to say that the evidence underneath all of those black bars is extremely damaging to these companies. And if it wasn't extremely damaging to these companies, they wouldn't be fighting so hard to hide it, which means that, unfortunately, they know exactly how damaging it is and they don't want you to find out. Okay, so moving on to the thing that we've been waiting for, and that is the new discovery documents that needed to be handed over by the 10th of November. Now, as you can see, it is presently, or at least time of recording, the 19th of November. So we are way past that. And I had just been waiting, thinking maybe it takes some time for files to be uploaded and accessible. And I wasn't exactly sure about the actual timeline that was going on. So 2 days ago, on the 17th of November, a status update document was released. And it says, on November 10, 2025, the TikTok defendants served supplemental responses to plaintiff's document request number specifying numbers 175, 176, 177, 185, and 187. Specifically, the TikTok defendants stated that based on their investigations to date, they have identified non-privileged documents responsive to requests 175, 185, and 187. Beginning this week, the TikTok defendants will produce these documents on a rolling basis until the productions are complete. The TikTok defendants are endeavoring to complete all productions by December 4th, but may require additional time given the intervening Thanksgiving holiday and need for privilege review, because of course they do. So just to go over specifically what document requests they have found, these are all in Exhibit A of the original discovery request surrounding Eugenia. So fully readable. It's just not all of these requests were applicable to Eugenia. So request number 175, all documents concerning any actual proposed analysis concerning the topics of addiction, compulsive use, problematic use, or safety of youth users on your platform. Request number 176 was any meeting agendas, presentation materials, handouts, background materials, or other documents concerning any actual potential adverse impact of your platform. This will be an interesting one to get the data on, because this will be surrounding the promotion and management that has been claimed by TikTok of Eugenia. Request number 178, all communications concerning investigations, lawsuits, media inquiries, or government inquiries related to the safety of children, teens, and youth who use your platform. Number 185, all documents reflecting communications with your employees, contractors, or vendors regarding when, whether, and how they should discuss the topic of whether use of your platform is associated with adverse effects on user safety, including addiction, compulsive use, and problematic use. But I think probably the most interesting one, and what I love is being brought to the forefront, is request number 187, and that is all documents received by you from any person regarding any adverse effect on the safety of a child, teen, or youth user of your platform, and documents sufficient to show your response to these user complaints. So all of those people that reported her account, how many do you think there are? That's going to be an interesting one. So this was my misunderstanding. I thought that because they had to get them there by the 10th of November, that means that they were filed within the lawsuit. But that was just them providing them to the plaintiffs. And then by December 4th, they need to be fully filed, which means that potentially a few days after that, or if they get an extension because of Thanksgiving and who knows, then Christmas and New Year's or whatever, I don't know. So even if they are released shortly after the 4th of December, I am expecting to see everything completely sealed, because that does seem to be the default state that the lawyers are submitting things. But I am now keeping a very, very close eye on the availability of that deposition with the TikTok employee. I think that would be a very interesting one, although some of my law nuggets have said that it's unlikely that one will be unsealed. We'll see. I don't know. I'm keeping an eye on it anyway. I will be keeping an eye on any exhibits put up that might have a link to the discovery document regarding Eugenia. And I'm also keeping an eye out for any updates specifically concerning this last update document. So it'll be interesting to see where it goes. Like I've said, these things move so slowly, and whether or not it will actually, achieve anything in the long run, I don't know. I'm probably naturally cynical when it comes to major corporations like this. I think there'll be a little slap on the wrist and then we'll go on as normal. But this case, although I kind of stumbled upon it because of Eugenia, and this case is becoming quite the fascination for me, and it's really interesting to dig into everything, and hopefully you found it interesting as well. So that's why I said it was kind of an update. It sort of is. At least we know what to expect and when, roughly, and I know exactly what I'm looking for. But if you're still here listening to me, thank you so much. I appreciate each and every one of you, and a big thank you to all of my cluckers who support on Patreon or YouTube memberships. And I've got more members only content coming out as well. Bear in mind that the members only content is exclusively stuff that I could not put on the free to view because YouTube just would not appreciate that at all. So if you also want to support the channel and join up, it is there for you, including single purchase options on Patreon as well. But that is all the clucks I have left to give. Stay golden, my little nuggets, and I'll catch you next time.
Hey,